just let me start my presentation. Hope there's no such problem. So, is the presentation also visible?
Yeah.
Okay, wonderful. So, friends, after 2 days of going through the lectures of on the valuation training course, I believe now you are getting tuned into the world of valuation profession, and now you are getting a fair bit of idea of how this training will is going to take shape, and what are the things which we have to have an understanding before we plunge into the world of valuation. So now you must have gone through the valuation approaches, the basic theoretical part of the whole content of the whole syllabus part, and then you must be starting with the practical aspect also. So today what we are going to do is cover another theoretical part. In our first lecture, I did cover on the valuation rules and the sections which were applied to the registered valuer. So today we are going to discuss something on the world of another act, which is the Sarfesi Act, which is a very important looking to the current context and going forward also. I believe that a lot of things are going to shape up, a lot of promising things are going to come up under this particular act. Now, there is always a question which comes into the mind, that why these acts are being taught in the world of valuation. Naturally, what has Sarfasi to do with the valuation world? Because valuation is altogether based on different type of input and approaches and standards and so on. So is it necessary to understand Sarfasi? Friends, let me tell you, all these acts which are incorporated in your syllabus, probably indirectly, they will touch upon your valuation profession. Indirectly, not directly. Be it the Income Tax Act, be it the IBC Act, or be it the Sarfasi, company law, or so on, they will be touching your profession indirectly somehow. So that is why these all sections, acts have been introduced, so that you have an overall holistic view. Obviously, not getting into details of each of these acts and understanding all the case laws and the practical scenarios. So probably we are going to touch the periphery of this particular act, Sarfasi Act, and try to relate it to the valuation world somehow. And then again, give you an insight on how as a profession we can encash this particular opportunity under Sarfasi. Now, where is Sarfasi applicable? Anybody can give an input that when will Sarfasi come into picture?
Debt recovery default.
When?
Enforcement of security.
Yeah. Okay. So
I think it is coming to when the loan is going to NPA, and for the purpose of reconstruction and of the company, this Sarfesi comes into the picture to salvage the company from the debt of the company.
Okay, so wonderful. Sushantji, he has given a bit of insight, and obviously others have also mentioned it correctly. So the Sarfasi Act will always come into the picture when there is a default committed by a company or an individual or a partnership or anyone. So going forward and looking to what is being spread in the business newspapers and all the channels and in the business community, that it is expected that in the next 1 or 2 years, there will be a lot of defaults, a lot of bankruptcies happening, and a lot of loans will turn into NPA. Do we all agree with this statement?
Yeah.
Yes. So we all believe that this is going to happen, because we as professionals are at the ground level, and at the ground level we are actually watching that what is happening with our client, and we can tell the reality whether what is being said in the newspapers, whether that is correct or not. And yes, to an extent they are correct, and though whatever they are saying, that this is the amount of default, this is the amount of problems the companies are facing, the businesses are facing, therefore there will be a lot of default happening. So if the default is going to increase, don't you think the actions under Sarfasi, recovery, IBC, and debt recovery, will this increase or not? So the answer is yes. they are definitely going to increase. And you will see a lot of traction happening in this world, especially in the world of IBC, insolvency, the Sarfesi Act, then the Debt Recovery Tribunal, then the under the MSME Act, where the people will be trying to file and recover the amount through the various provisions which have been introduced for MSME companies of applying interest rate if the payment is not made within particular date. Then in terms of banking sector, a lot of provisioning, NPAs, recovery, OTS, settlement. These are the, areas which are upcoming. Now, these are the areas which are upcoming means, are there any professional opportunity? So I would say answer is yes. So friends, the irony with our profession as chartered accountant, as company secretary, as cost accountant, that we work on both sides of the profession. When the company is growing, we have an opportunity. And then when the company is going down, we have an opportunity. So on both sides, we can encash that particular opportunity. So friends, probably after understanding Sarfesi Act and IBC, there can be certain new kind of opening for all of us. And we can rethink our future course of strategy as a professional. So let me start with the world of Sarfesi, where we will be covering two angles, Sarfesi Act and enforcement rules. So one is purely on the basic provisions of Sarfesi, and then there are certain rules that how the banking segment can, enforce their security interest. So what are the objectives? Why the Sarfesi Act came into picture? That was in 2002, I believe, when this act was introduced. And the whole purpose was to create a framework for the first word, remember from exam perspective, the securitization activities in India. That was the initial purpose of securitization activities in India. And the whole purpose was that, over a period of time before 2002, for any recovery activity action taken by the banking or the lenders or the financial institution would used to take, years and years to actually get hold of the assets which were charged with the particular lenders. And that is why Sarfesi brought in a total change in the mindset of the borrower and the bankers. So it created process where the recovery of asset could be done without the court's intervention. That is the biggest essence of this Sarfesi Act. And it was termed to be a very draconian act initially, but now it is now established act and accepted fact that, we are subject to a lot of actions by the lenders. So first is securitization. Second is enforcing the security interest without court's intervention. And third, it brought in a new set of, dimension, new set of companies in this country, in this economy, and a new set of business opportunity in the form of asset recovery companies, asset reconstruction companies. It gives the procedure for transfer of NPS to asset reconstruction companies. So three major objectives, if you see, one was securitization of asset, the second was creation of asset reconstruction companies, and third was enforcing the security interest without court's intervention. Three primary objectives of the Sarfesi Act. And as I said, going forward, all these three will play a prominent role in what? In recovery and restructuring of Indian businesses in times to come. So this act provides, as I mentioned, for recovery of NPS for three modes. So we need to understand what is securitization, what is asset reconstruction, and what does enforcement of security interest means. So let us understand these technical terms. So major focus would be on the ARC part and the enforcement of the security interest part. Lately, you must have been watching all the newspapers, and in last 2 years, you must have seen that the newspapers are flooded with, big ads, not ads, big information given by a lot of bankers regarding takeover of the assets of the defaulting borrowers. So you'll see a full page ad coming out in the newspapers, and each bank is highlighting the name of the borrower, the property they are attaching, and the minimum reserve price which they are keeping for selling of that particular asset. Now, how is this done? This is through the Sarfesi Act. This is possible, friends. Without the Sarfesi Act, probably these big ads could not have been possible. So, as the time progresses and as the number of defaults increases, you will find that the number of ads which are in the newspapers are going to increase. So friends, so let us go ahead and understand the act. So the act was promulgated in the 21st June 2002, and the whole act name is Securities and Reconstruction of Financial Asset and Enforcement of Security Interest Ordinance Act. When the act was introduced, as I said, it was considered as a very draconian act. And when the act was introduced, it was challenged in various courts on the grounds that it is in favor of the lenders, because it was giving a direct benefit to the lenders of taking over the assets of the borrowers. And after a lot of hearings and filing of public litigation cases, finally it was decided in the case of Madhya Chemicals, where the government of India, the Supreme Court, upheld the provisions of this particular act and upheld the validity, the constitutional validity of this particular act. And thereafter, it was no looking back. And since then, the bankers have got an upper edge, and naturally they should have got, because the problems which was faced before 2002 was quite heavy and quite cumbersome. And that is why this act really brought in an ease of process of recovering the amount of the default. So a quick snapshot of this act, which talks about the world of ARC, Asset Reconstruction Company, from section 3 to 12. Then it will talk about the enforcement part, that is from 13 to 19. Then a new agency was created by the central government in the form of SARSAI, that is Central Registry. So there are provisions regarding that. And then the miscellaneous provisions, which are not relevant. And then the enforcement rules, which will talk about the various process, how the bankers can recover that particular amount. So in terms of exams, how many questions might be asked? Maximum two, not beyond that, and minimum one. So there will be one question definitely, but not beyond two, friends. But that to go through this 1 hour or 1.5 hour of lecture for understanding this act for only getting 2 marks, I believe it is worth, because if you are not aware of the various provisions of the Sarfesi Act, I think every professional should be aware, because one of your clients, maybe a few of the clients are getting impacted by this particular act, and it is very important that the basic provisions should be kept in mind while advising the clients. And other than that, I believe that it is bringing in a professional opportunity because of the number of stress assets going forward. See, apart from the Sarfesi, let me tell you, what you can do is, see, as I said, you have to take a look from the holistic point of view. It's not only about Sarfesi, but clubbing it with IBC, clubbing it with Sarfesi, clubbing it with the Debt Recovery Tribunal, clubbing it with the insolvency of individual personal guarantors. So if you take a holistic view of all these 4 acts, and asset reconstruction company and stress asset funding, all these parts are under one umbrella, and I would term that umbrella as you become an expert of a stress asset. So you call yourself as an expert, as a consultant of a stress asset, and I believe that the stress asset consultant has got a big opportunity today if you have got the right sources in terms of in the banking world, as well as in the world of ARC, as well as in the world of stress asset funding. If you have got these 3 connects properly, I believe that you have got a very promising future for all of us. That is for sure. Because lately, when I got into the world of insolvency for last 3 years, I got this opportunity to deal with a lot of stress asset, and then I got to know that this is altogether a different ball game, but a big opportunity. And in last 1 year, I have done few deals on the stress asset part, and that is why I'm trying to highlight this particular point. Okay, so what does the act say? So let us go through some various definitions which are important. So this act applies to a lot of, especially to financial assistance, and which purely means any loan and advances granted by the financial institution. Now, remember, financial assistance will always include the debentures or bonds which are subscribed by the investors also. So today, if a company has issued a debenture or a bond, can the debenture holders take that company under the Sarfesi Act? The answer is yes, because the Act here mentions that financial assistance will include that type of particular advance or loan given by the company, a loan given to the company also. Then any lease arrangement? Answer is yes. So be it hire purchase agreement or financial lease, both are covered under the Sarfesi Act. So default, we all understand what does default mean. So it means a non-payment of any debt or any other amount payable by the borrower, consequent upon which the account is classified as NPA. And that is the meaning of default. Now, there's always a question, what is the default date? Now, if I ask you what is the default date, so can anybody answer me what is the default date?
I think when it becomes that debt becomes a stressed asset, declared as doubtful after 90 days.
Okay.
No, I think 1 day after the due date.
Yes.
It was past the due date.
Okay. Right. So somebody said that 1 day after the due date, the answer is yes. So date of default is the day when the amount was due. And the next day, if you're not making the payment on that day, it's next day the default happens. So friends, that means today you don't have any much leverage or leeway to, extend the default date. And because that particular time period will start immediately the next day. So default date is very important. It is different from the date of NPA. Remember, date of NPA will happen after 90 days, while date of default may happen as early as the default happens. So the default means whenever you are not able to pay any amount. So it happens, in lot many cases in a normal circumstances also, there's always a possibility of default. So because of certain timing issue, fraud, banking issue or anything. So even your intention might be good, but somehow if you are not able to pay that amount on that particular date, so then it is subject to default. And then once it is default, then a lot of consequences happen. What is security interest? The word itself gives the explanation. It means purely the right or title or interest of any kind upon the property created in favor of any secured creditor. So it is nothing but the mortgage, the charge, the hypothecation, assignment, right or title or interest on any tangible asset has been created, retained by the secured creditor. So that is known as a security interest. So in general, we know that in case of lot of in all loan cases, we need to give the security. So when the security is given to the bankers, so that is the security interest the bankers have created on that particular property. A lot of dispute have arisen on the security interest part. So I think over a period of time, things have evolved, structured, now very clear that what will be considered as security interest, what documents have to be created for creating that security interest, whether charge should be there or not. So now things are now stabilized. See, all these laws, what they have done. Initially, there were a lot of hiccups, problems, not much of clarity. But after 5 to 7 years, the laws get stabilized and things are very clear. That is why today, bankers have got an upper hand. Maybe if you had asked me this question 10 years back, I would have said no, because at that time, still, again, the Sarfesi Act was still evolving. But now it has evolved, well settled, all the case laws have settled, and therefore you cannot escape or you cannot find any fault in this particular law and find any provision which you can make use of to escape this particular Sarfesi Act. Yes, along with that, remember friends, along with the tangible asset, any assignment or any interest in tangible asset which is created, that is also creating the security interest. So it will cover both the tangible as well as the intangible asset part. Okay, this act will not apply to in certain cases. It naturally happens in every act. So it will not apply to the lien on any goods under the Contract Act, pledge of movables than the Indian Contract Act, and very specific to Aircraft Act and Merchant Shipping Act. Not much of relevance. So they have given certain exceptions where this act will not apply as per Section 31 of the Sarfesi Act. So I'm not going to details. Yes, one thing which is two things which is important. The three HINJ point. This is important. First is that if the amount is not exceeding 1 lakh, it is not relevant. So anything which is below 1 lakh, it will not attract Sarfasi, which is very natural. Why would a banker take so much of pain, incur so much of cost for recovering only 1 lakh? Then no security interest can be created in agricultural land, right? This is very important. So that is exempted. And the third is any case in which the amount due is less than 20% of the principal amount and interest thereon. So that means now your loan outstanding is less than 20% of your original loan amount. Then you may be exempted. Then you are free from the clutches of Sarfesi Act. So these are the 3 points which has to be taken care whenever Sarfesi Act is triggered. So from exam perspective also, it is important to remember these 3 points. Okay. Now coming to the asset reconstruction company. So after this act was introduced, you could see a flurry of a lot of companies being formed in the name of asset reconstruction company. And they are the companies who are registered with RBI under Section 3 of the Sarfesi Act. And the whole purpose of this asset reconstruction company was to, two things. One is securitization, and second is the asset reconstruction. That means what they will do in the asset reconstruction. So objective was very clear. It was defined that what is the way out of the ARC. So they acted as an agent for any bank or financial institution for recovering their dues from the borrowers on payment of fees. So first was they could recover the amount from the borrowers by charging certain fees. So they acted as agent. But obviously, I think no company would be created only to act as an agent. I think the job of agent for recovering amount is something different. So ARC over a period of time has not evolved themselves as an agent, but more or less been involved, act as a manager of borrowers' asset taken over by a bank. That is their major job. Then to act as the receiver of properties of any bank and on any ancillary businesses with the prior approval of the RBI wherever necessary. So when it talks about agent, it does not mean they'll act purely as a recovery agent. But the purpose was that to take over the business and then run the business. So if you club the first point and the fourth point, then the job of ARC is clearly defined. That the purpose was not only to recover the amount, but to ensure that the business is carried on so that the banks are able to recover their amount over a period of time. That was the whole objective of ARC. Now, the other objective was again, because banks were loaded with a lot of NPAs in their books of the account, and that gave a wrong impression in the banking's balance sheet and financial statement, and it did not represent a good picture in the eyes of World Bank and all the international financial institutions. So the government thought that what is the best way out? The best way out is to remove all these bad loans from the banking world, and why not shift all these bad loans to some other company, and so that the bank's balance sheet remains clean and they comply with all the Basel II, Basel III requirements. I hope you are aware of what are Basel II, Basel III requirements in the banking terminology. So there were certain capital adequacy requirements which were framed under Basel II, Basel III, and which called for reduction of NPS from the banking books. And ARC was a mode where the bank's loan book was shifted, bad loan book was shifted from the bank account, from the bank's balance sheet to the ARC. So that was the objective why this ARC was created, and obviously to help the banks to recover the whole amount along with carrying on the business. So the basic purpose of ARC is the activity of converting a bad or a non-performing asset into a performing asset. I think that is a prime objective, and that should be the intention of ARC. That how to ensure that the NPA becomes a performing asset, how to ensure the job creation is there, the employment is there, how to ensure that particular activity of the manufacturing concern keeps on going. And if that is solved, if that is achieved, I think ARC is doing a good job. So it involves a lot of steps. So first step obviously will be involving where the bad asset is transferred to the ARC, including the underlying hypothetical asset. Now, how does this happen? Any idea? Anyone who could explain? How will this happen? Purchasing of bad asset?
Through some SPV, is it?
Okay, through some SPV. Okay.
To a trust.
Yeah.
Through a trust.
Trust, which will form a
True.
trust.
By taking some haircut?
Yeah. So somebody mentioned through a trust. Okay. So through a trust, that is an SPV. That is a possibility. So an SPV could be created, a trust could be created, and somebody mentioned by a haircut, which is absolutely correct. So all 3 points are actually correct. So through creating an SPV in the form of a trust or any other structure, and through some haircut. Now, what does haircut mean? Simple meaning. So the bank has a loan outstanding of 50 crores from any borrower. So ARC will come and say that it will buy out that loan at 30 crore. So bank is happy that it is receiving 30 crore today, and it transfers that bad loan from their books to the books of ARC. Now, what is the amount which is recoverable from the borrower by the ARC? Is it 30 or is it 50?
50.
Correct.
50.
Full
Yes,
amount due.
the full amount is due from the borrower. So ARC gets that benefit that though it is given only 30 crore to purchase that bad loan, but in fact, it is possible that it can recover 50 crores. So that is why this business was very attractive from the ARC point of view, that you get certain loans at a very cheap amount, a peanut price, and then if you are able to turn around that business, you tend to gain heavily. So that is why it was a very lucrative business for a lot of ARC. But then in due course of time, again, it was a nation state, things evolved, people got into trouble. ARC also could not, establish their credentials of turning around the company. Economy did not support, and a lot of problems came in. But yes, now because things have again now stabilized, ARC have defined structure. People know how to turn around. There is ecosystem now there. So you'll find that a lot of ARCs are doing good job. And out of 10 deals which they make, 5, 6 are not successful, and 3, 4 are successful, which give them enough returns, enough cushion to carry on their business of ARC. Then the purpose is again financing the bad asset into conversion of bad asset into good asset using any form of financing, that is bonds, debentures, securities, and cash. It could be anything. But remember, it is not mentioned as equity. So if they are buying a bad asset, they will not fund that bad asset through equity. It can be through bonds. It can be
There is sir.
Yeah.
There is negotiation between the bank and ARC company for negotiation for the how much which they will take this bad loan negotiation.
Yes, negotiation keeps on happening. So one is directly the ARC would approach the bank to take over that bad loan. So ARC keeps on searching of such business opportunity with the company, with the banking sector, or there the other possibility is the defaulter may also bring an ARC. There's also a possibility. That is why I say, as a professional, we should explore this opportunity where we can play an intermediate role of convincing the borrower, defaulting borrower, that they should transfer this loan, get this loan transferred from the banking sector to the ARC. So that, now
There is also bidding between the asset reconstruction company to getting this loan.
yes, if it is a good borrower, it is a good prospective company, there's always be a bidding, because bank wants to maximize the inflow. So they'll always call for bidding approach. So that is naturally there.
Okay.
Because see, if a company has a good prospect, the ARC would be interested. And today, if you see, you will find that there are dedicated ARCs. Now, dedicated ARC means they are looking for sector specific businesses. So there might be ARC who are only interested in steel. There are ARC only interested in real estate, and so on. So so there are so many now different variants of ARC coming up, and they are always on the lookout for pouching all these bad loans within the banking sector. They evaluate, and then they apply to the bank to take over that loan. And if there are multiple ARCs, bidding will happen. So with the background, I think with now the concept of ARC is clear. Let us understand the process of securitization.
Mr. Khandelwal,
Yeah.
I have a small doubt.
Yeah.
do this RC take over the management or participates in the management of this company when they are pumping the fund by way of
Yes.
bond or even the security? So do they
Yes.
participate in the management of that company?
Yes.
Okay.
So there could be different types of deals which could be done. And as I told you, the one deal could be, because now the ARCs are dedicated, on specific industry. So they have built an expertise, let's say, of steel industry. So they will always approach a bank where there's a default of the steel industry. And because they have got experts within their community who will be boarded on the management part of the company, and they will try to turn around. So that is one way. The other way, as I told you, that if you as a consultant arrange an ARC deal with the borrower, bank, and the ARC, then the deal could be in such a way where the ARC will not interfere in the day-to-day operations of the borrower. That might be a possibility also. So ARC only comes as a financial investor, a financial person to take over the loan. That is also a possibility. But when the ARC takes over the company from the bank directly, so they will like to have their own management team, or they can club it with the existing management. That is a possibility. Okay, so let us understand the securitization concept, friends. Now, what is the securitization? It is a process of pooling and repackaging of financial assets into marketable securities that can be sold to investors. Now, what happens? Though this concept has not developed so much in the Indian market, but it is there. It's not that it is at a nil stage. It is there at the highest level in the banking world. But worldwide, securitization is a great concept. And just to explain what can happen in securitization is, let's say, a bank has, let's say, 200 housing loan given to different individuals. And they know that the 200 housing loan will have a maturity after 10 years. So today banks have funds, so they give this loan to all the 200 individual home buyers. Now, once the banks are now, given all the funds, they want more funds to, increase their business. So how do they increase their business? Because they don't have funds. So what they can do, they can pool all these 200 loan accounts and sell all these 200 loan accounts to another investor. And that investor will take those loan accounts and give some money to the bank. So what happens in this whole process? The bank receives more funds, and the assets are pooled and given to a particular investor, who in turn will get some interest because he has given a loan to the bank against all these pooled assets. And the investor will give, the bank will pay certain interest on that amount, and that interest will be the earning of that particular investor. And what the banks are getting fund, and from that fund, the banks can again fund more home buyers. The investors' advantage is that, let's say there's a foreign company who wants to make an entry in the Indian market, in the Indian retail or real estate market. So they cannot open a bank because that will require a lot of permissions, legal issues. So what do? They approach let's say a bank and say that you please securitize all these home loans and give it to me, and I'll give you money. So the advantage the company, the investor, is that they are able to have an entry in the Indian market specific to whatever industry they want, and they are secured because all these loans are secured by the asset. So especially in the home loans, this securitization is a good way of raising funds from the banking part, because home loans are, the chances of security is more in home loans rather than the business loans. So that is the process of pooling. Yeah.
Suppose a bank transfers all the NPAs to an asset reconstruction company at a certain haircut. The same bank can buy from the ARC the securitized portion of the assets. Is it allowed?
You mean to say that there's a bank A which has sold the assets to bank some ARC company B, and later on the same bank again buys back from B.
So the ARC B will securitize whatever they have bought so that they can sell it to investors, and the investors can also be financial institutions like the same bank which actually sold it in the first place.
Not directly, but yes, there could be certain SPV where the bank A is a part of that SPV.
Okay, understood.
And these are all legal structures which are created at the highest level. And when you do a bit of research, data mining, you will come to know these are the deals which are happening. So finally, it is the bank A only which is funding this ARC deal.
That's exactly what I'm
You
trying.
know, it may happen. You see, when you go into the intrinsic details of all these deals which you read in newspapers, you will come to know, yeah, this SPV is belonging to this company, bank, and this bank is making partnership with B party. B party has a subsidiary of A, and then, you know, all these deals are structured. So it may happen, you know, there's a possibility.
Thank you.
Okay, so friends, securitization, I think a very simple way of raising funds. The whole concept of securitization is, remember, is to create in one line, create liquidity through illiquid assets. Create liquidity through illiquid assets. Because as for the bank today, that home loan will derive money after, you know, after 10 years, will generate money after 10 years. So for that 10 particular years, that asset is an illiquid asset for the bank. So they are trying to create liquidity through that illiquid asset. So the steps are very clear. So acquisition of financial assets from any originator. That originator is the bank. A raising of funds from the qualified institutional buyers by issuing security receipt. That is the, for raising money, they will issue instruments, and then the funds will, the asset will be acquired and the funds will be transferred. This is the whole process of securitization. So two words, two things which we understand that ARC would be doing. One is taking over the bad loans, and the second would be, you know, taking over a bad loan or a good loan. It may be both the possibilities. Securitization does not only focuses on bad loan, it may focus on the good loan also. So pooling of the assets of same kind, as I said, 10-year home loans. So that is a pooling of assets of the same kind, and then selling it to the qualified institutional buyers. Regarding certain procedural part from the asset reconstruction company, the procedure is simple. Obviously, they need to meet the criteria of RBI. So they cannot commence a business until they have got the certificate of registration. And very important exam point of view, remember friends, they must have a net owned funds of not less than 2 crores. You know, so that is the exam question. So 2 crores net owned funds are required to get into this business of ARC. Conditions, the conditions are they should not have incurred losses, because every year they have to renew their certificate. So they should not have incurred losses in the 3 preceding financial year. And they have made, you know, the fund arrangement should be there. Without the fund arrangement, no ARC can perform, because ARC would require fund. So the fund arrangement for the realization of financial assets acquired for the purpose of securitization, and they should be able to pay the periodical returns to the investors also. So that all arrangements should be there with the ARC. So they have to prove it that the arrangements are there. And obviously, with all the technical qualifications from the director's point of view, that has to be fulfilled. Yes, I think rest of the things are very normal. Yes, one sponsor, that is sponsor of the asset reconstruction company. Sponsor is an individual, and who would be the person who would be responsible for bringing in the funds in the initial level. So he meets the criteria as specified by the RBI. Then the RBI may cancel the certificate of registration when then it ceases to carry on the business of reconstruction, obviously. Then ceases to receive or hold any investment from qualified buyer. So there is nobody who is willing to invest. So they don't have any funds. Then obviously, if they are not able to fulfill any conditions. So these are the 3 normal reasons why the ARC certificate is cancelled. So remember, friends, all the ARCs have to get themselves registered, and cancellation can happen anytime. Then coming to certain specific things about ARC, how do they acquire the whole loan, bad loan? So normally, as I said, they acquire the bad loan by issuing a debenture or a bond or any other security in the nature of debenture, and the deal is done with the investor and the ARC that I'm issuing a debenture with, let's say, 7%, 8%, 9%, and this debenture, this amount will be used for buying out this particular bad loan or this particular group of bad loan. So all the deals, all the agreements are done. So there's a back-to-back arrangement. So there's one arrangement with the banking, and another arrangement is with the qualified institutional buyer to fund that particular bad loan. What happens in terms of legal structure, that all the rights which are attached to that particular bad loan will get transferred to the ARC. So that means now the bankers don't have any role to play in the borrower's account, and the right of the asset, the security interest, and right of recovery will all get transferred to the ARC. And that is what is required from the banking perspective also, because they are not the best person fit in to actually administer or manage the affairs of the company. Yes, what in the whole process, what has to be done? The bank or the institution, they may give a notice of acquisition of financial assets by the ARC to the concerned obliger and any other concerned person, including the ROC. And basically, the process is that the information has to be given to all the people who are involved in this, who are the stakeholders. So information has to be given to the borrower along with ROC, because the charge will get transferred. The borrower should be aware that this loan has been transferred. Therefore, this notice has to be given to all the people. Yes, we have discussed the fundraising by ARC, that how they are able to raise funds. So the asset reconstruction company may raise funds from the qualified buyers by formulating schemes. So they will develop the various schemes for each of the debenture issue, and separate account has to be opened for each of the scheme. And as I said, scheme it could be steel scheme. So from steel scheme, they could raise from 5 qualified institutional buyers. They would raise amount of 50 crores, 100 crores, 200 crores. So for each scheme, they will create an each account. The amount will come from that particular institutions or buyers to that particular account, and then all the transactions will happen from that particular account only. So measures taken by ARC, once it takes over the bad loans, what is going to happen? So as I said, once the bad loans are taken over by the asset reconstruction company, the possibility is that they may take over the management. So they take over the proper management of the business by changing or take over the management of the business of the owner. That may be a possibility. But normally they do not do like this, because they know that without the help of the old management, they will never be able to run the business. So they take support of the old management to run the business. They may sell or lease a part of the whole business of the borrower. So if they think that there's a part which is not working properly, they may sell that particular business. Reschedulement of the payment of debts, whatever terms and conditions are there, they can reschedule it. Settlement of dues payable by the borrower, enforcement of security interest, taking possession of the secured assets, that is also a possibility. So they can take over all the assets. The administrator can be appointed, the security guard can be appointed, and they can run the show. They can always convert the debt into shares also of the company. That is also a possibility. So all these possibilities are there. All the various areas are open, and you have to, again, as I said, come out with an open mind. Depends upon deal, depends upon the industry, the nature. So each deal is a different deal, and it has to be structured based on the business. So this is all about the ARC part. I think we have covered on the ARC part, right? So let's throw some questions here, and let us answer it on the screen. Yeah. I hope you should get it correct. So here we come, the first question.
A.
Anybody else answering? Nobody? I think we had discussed this. The amount is very clear.
Answering in the chat.
Okay, chat box.
We're all typing
Right,
all the chat box.
Yeah, sorry. So A is the correct answer. Very good. Yeah, A is the correct answer. Question number 2. I missed out the chat box. right? So yes, correct answer is A. Yeah. Because the questions are long, the answers are also long. So though it is very clear, especially already there in the A part, that is why I'm giving some time to read the remaining answers also, remaining part. Okay, so here is a confusion. So somebody has mentioned C also. So correct answer, Sumit ji, Anil ji, Harmeet ji. Sushant sir, why did you answer C? I don't know. Any reason for answering C? So the correct answer is B. Correct answer is B. Yes, so we're getting an answer is B, B, C. Sudipta sir has answered C. So the question is, if you can read the question, as I think I did discuss this in the last class, if I had missed out, just trying to reiterate that particular point, which is very essential when you solve all these MCQ, especially when it comes to theoretical MCQ with negative marking, friends. Uh, did I discuss this about the uh, the mind, hand, and eye coordination, and you are trying to look at the obvious answer, a strategy for exam? Can somebody just mention it, whether I discuss this or not? Okay. Okay, Mr. Subramaniam. Uh, so, friends, in all the MCQ part, please remember when you are reading on the computer, when you are reading it in the computer, there are three things which are working on your body, just trying to correlate with your behavioral and psychological and the physical movement. One is the eye through which you are reading the computer. The other is the hand from where you will be ticking the answer. And third is the mind, which is trying to interpret the question. So there has to be coordination between the mind, the eye, and the hand. So what happens? Behaviorally, the eye will always look for an answer which is already placed in the permanent memory of your mind. And the mind will always try to look for an obvious answer which is stored as a concept in your mind. So you don't want to go beyond the concept. You don't want to think beyond the concept, and it will always look for the answer which is there, and that is an obvious answer. And eyes will always search for that obvious answer. It may not be the correct or the right one, I don't know, but then the eyes will always search for the obvious answer, and the hand will try to look at the eye and work with the coordination with the eye. So what happens, friends, in the MCQ based question, the questions are framed in such a way where one of the answers in all the four choices will always be the obvious answer which your mind is, which your mind is looking for, which your mind is, it is fixed in your mind. So they will attract, that answer will attract your mind. Oh, this is the obvious answer. And sometimes it is the correct answer, sometimes it is the wrong answer. I'm not saying that it is always the wrong answer. So sometimes it is correct, sometimes it is wrong. So it depends upon the type of question they have asked. So therefore, whenever you are, answering a question which you think is very obvious, oh, this should be the answer, yahi to answer hai, then you should relook at the answer and the question. rather than answer, you should relook at the question and then answer the question. Because, it's a behavioral concept which you always need to study. When you read books, when you read other books, then you'll understand all these behavioral concepts. So here in this question, if you relook at the question, the word is except. And normally in a hurry, because of pressure, that the exception, the not word, the least likely word, not applicable word, exception word, the odd one out, that is normally missed out, because your mind is always working on the positive side. Because mind has been trained in such a way, when you study, you never look at a thing from the negative perspective, you always look at a thing from a positive perspective. So that is why obvious answers have to be rechecked. Obvious answers have to be rechecked. Please remember this, one of the strategy for exam, because as I told you in my last class, I found participants failing at 59.5, 59.75. That is only because of one question which they are taking it as wrong, and that is why they are getting a negative marking of 0.25, friends. So here the word is except, so the correct answer would be what now? So correct answer is B for Bombay. Yes, Mr. Rohit, Mr. Sudipta, Mr. Ranjan, you are correct. Because it is mentioned except, cannot. See, remember there are two words now, except and cannot. But we have studied and have discussed that they can sell or, a part of the whole of the business. So there are two negative words, the except part and the cannot part. So that is a trick these MCQ questions play with you. So please do remember. Yeah, so I missed out on the answer part. Can again. So the correct answer is, I missed out on the answer, but D, A, A,
A.
A. So when the cancellation can be done by RBI, when the ARC fails to maintain accounts in accordance with the requirements, submit or offer for do not obtain prior approval of the RBI under section 3. So I'll just go back to the cancellation so that now, yes, so you can refer to the cancellation provisions. So one is they cease to carry on the business, cease to receive or hold any investment, has to fail to comply with any conditions subject to which certificate of registration has been granted. Then fails to comply with any direction issued by RBI under provision of this act, maintains accounts in accordance with the requirement, fails to maintain account, submit or offer for inspection, something like that. And last point is obtain prior approval of RBI required under subsection 6. So let us see the question.
It should be then for all the four answers.
That is what I'm trying to say. Yes.
Yeah. I was also confused because all seems to be.
Yes. Okay, so all the four answers are correct.
Correct.
Right. So all the four choices. 4E, yes, Sudipta sir. 4E is the correct answer, where E is all the above. This one, I think everybody should get it correct. Yeah. B is the correct answer. So amount is 1 lakh as we have discussed. Okay, so coming to the second part, friends, about enforcement of security interest. So how the companies would, how the banks would enforce their security interest? So very important, I think, when you read the newspaper ads, probably you will find that one of the sections, the provisions are mentioned, which is relates to enforcement of security interest. And in the banking world, and for any defaulting borrower, you will find that they will mention two sections, 13.2, 13.4. That is normal terminology. They will always talk in terms of that 13.2. We have issued the notice under 13.2. We have issued notice under 13.4. That is the normal terminology which they talk about. So what is this 13.2 and what is this 13.4? They all relate to enforcement of security interest. So this act gives the power to the banker that when the borrower defaults, as I said, defaults, that is from day one, not from the date of NPA, to issue notice. They will issue a notice to the defaulting borrower, either calling or asking them to repay the debt within 16 days from the date of the notice. So now the act, the time period starts. These time periods are very important nowadays because you will see in lot many cases, be it IBC, be it the Sarfesi and other areas, especially again in case of personal insolvency. Now these dates of notice are becoming very important. And as a consultant, I think we should be aware of all these provisions, especially the Limitation Act, because Limitation Act is very important as of today, which enforces which gives them a certain kind of liberty to the borrower, that if they somehow skip this Limitation Act, then they are saved from all the problems of the Sarfesi and IBC. So Limitation Act, the Evidence Act, the Sarfesi Act, and clubbed it with the IBC, very important from the default date, NPA date, and the number of days which are mentioned in issuing the notice. So one is that within 60 days they have to repay the amount, and if the borrower fails to comply with the notice, then the institution has got the right to enforce security interest by taking the following steps. They will take possession of the security. They will sell or lease or assign the right over the security. That is, the assignment is also possible. Then they can appoint a manager to manage the security and ask, very important, the fourth point, very important, exam also relevant, and in general, they can ask any debtors of the borrower to pay any sum due to the borrower to the lender. Not paying the amount to the borrower, but paying that amount to the lender. In a lot many cases, it has happened, and then the dispute arises. And why did you pay that amount to that particular lender? And now, with the recent change in the RBI guidelines, RBI guidelines, 10 years back, there was a lot of ways out to, divert the fund by opening a current account in some other bank, and then you can do the transactions in that current account. Nobody would question that. But today, opening a current account in any other bank when you have already defaulted, or when you have having a loan account with a particular bank and opening a current account in some different bank, is not a possibility. It is very difficult. So, going out of the clutches of Sarfesi has become very difficult, and therefore, I think we all have a responsibility to educate our clients, especially who have taken loan from banks, that they should comply with all the regulations. Otherwise, times to come, you don't have any option. Your assets will be taken over, you will be thrown out of the business.
Pardon, sir?
The assets will be taken over and you will be thrown out of the business?
No, I'm talking about the debtor. The borrower, is it mandatory or binding upon the debtor that to pay directly to the lender?
Yes.
If it does not comply with, then any legal action is available with the lender?
Yes, it is binding.
Oh, it is binding.
Okay, so security interest, I think we have discussed what is a security interest, and nothing to discuss in that. Certain provisions regarding the security interest, that if there are more than one secured creditors, which happens in case of multiple banking, consortium finance, the decision about enforcement of Sarfesi provisions will be applicable only if 75% of them are agreeing. So that is one of the preconditions in case of multiple banking. Then the Sarfesi Act allows the secured creditors to take steps to enforce the security interest in respect of any debt of the borrower that is classified as a NPA without the intervention of the court or tribunal that we have already discussed.
So this 75% is by value or by number of lenders?
By value.
By value.
So section 13(2), friends, very important. As I mentioned, these are the two acts. So any borrower who is under a liability to a secured creditor makes any default, then the secured creditor may require the borrower by notice in writing within 60 days. So that is from the date of notice, from failing which the secured creditor will be entitled to exercise all rights under subsection 4. So 13(2) will ask, will tell the banker to send a notice. So only the notice is being sent. And 13(4) is very important, that under 13(4), the assets will be taken over. Remember. So action if no response. So in case the borrower fails to discharge his liability in full within the period specified in subsection 2, the secured creditor may take recourse to one of the following measures: take possession of the secured assets of the borrower, take over the management of the business, and the last part, provided that the right or transfer of by way of lease or assignment or sale shall be exercised only when the substantial part of the business is held as a security for the debt. See, normally when you take over the business, what can happen? That you can sell the business only when the major part of the business is held as a security. So if only small part is held as a security, you cannot sell the business. So that is very logical. That should not happen. So the possession is taken under 13(4). Notice is sent under 13(2). Remember, notice under 13(2), possession under 13(4). What will happen in case of default under debentures which are issued? So then the debenture trustee who is there, who is appointed as a debenture trustee, he will be entitled to enforce security interest in the same manner as provided under this section, because there is no banker involved. So the debenture trustee will take the role of the banker or the lender. The contents of the notice, firstly, because it is a legal notice, so properly has to be drafted. So it will contain the details of the amount payable, which is very important. You have to freeze upon the amount which is payable with all the calculations done. And the secured assets intended to be enforced. So you need to mention that these are the assets which are mortgaged, so this will be enforced. If on the receipt of notice, if the borrower makes any representation, raises an objection, then the secured creditor obviously will listen to him, and obviously they can present their objection also. So 15 days time is given for the whole process. From exam perspective, 13(2), 13(4), practically also 13(2), 13(4) are important. Then, as we have already mentioned, what are the steps taken by secured creditor? So he can appoint any person to manage the secured assets, required at any time by notice in writing. Any person who has acquired any of the secured assets from the borrower or from whom any money is due, then they may be called upon to pay such money as is sufficient to pay the secured debt. So as I said, they can ask any particular person who has to pay some money to the borrower, they can ask them to pay that amount to the lender. So they can take the help of the district magistrate within whose jurisdiction the particular asset is going to fall in, and with the help of that district administration, if required, they can take possession of such asset. Because in lot many cases, you might find that might read in newspaper that the collector along with his team went to acquire the asset as per the Sarfesi notice, because in that case the borrower may not be supporting the whole process, and though it is in default, everything is clear, but still they are not giving away the assets, especially when it comes to the home loans or where the home is given as a mortgage. So that is important. So in that case, we need to take support of the administration. Management will be taken over, and what will happen when the management is taken over? So that is important. So when the management is taken over by the ARC or under Sarfesi 13.4, the secured creditor may publish a notice in the newspaper, appointing as many persons as they may think fit. And in case in which the borrower is a company, they can tell that these are the people who are the directors of that borrower. Now the new directors will be appointed, so they can tell that. Or they can mention any person who is the administrator of the business of the borrower. So they have to give a public ad. Can the business again go back to the original owners? So answer is yes. Obviously, that option is always there. And the condition is then when you have repaid the whole amount as mentioned in the 13.2 notice. So when the management of the business has been taken over, the secured creditor on relation of his debt in full give the business back to the original owner. Yes, so that is the normal. Yeah. Objection, if any has to be raised, that is covered under section 17. So any person aggrieved by any measures taken under section 13.4, which takes over the possession of the asset, may make an application along with such fee, very important, to the DRT. So the adjudicating authority which comes into the picture now is the DRT, Debt Recovery Tribunal. And you must have seen that after this Sarfesi Act, a lot of activities do go on in the Debt Recovery Tribunal. And wherever the DRT is situated, especially it is only at one place within a state. So there are a lot of opportunities in terms of attending the hearing at DRT, and there all the objections are raised by.
Sir, what is the fees prescribed with the application?
Pardon?
What is the amount of fees which is prescribed with application?
Fees is not enough. I think it is around 2,500 or so. Fees तो ज़्यादा होती नहीं. Application file करने की fees तो ज़्यादा होती नहीं. Now only problem is it has to be done in 45 days. Now when we have to file an appeal, we all know that हमें कुछ ऐसा तो नहीं है that we need to pay a certain amount which is on the basis of default amount. So answer is no. So if you are filing a case at DRT, you don't have to pay any amount of the outstanding loan. ये एक थोड़ा benefit दिया गया है, that is the benefit given to the borrower part. But if the order is released by DRT and it is not in your favor, then you can again file in the DRAT. The appellate tribunal is always there. So within 30 days, you can file an appeal at the DRAT. But in that case, you have to pay the 50% of the outstanding amount. That is a problem, but which can be reduced to 25% at the discretion of the tribunal. So very important, friends, this particular thing of the filing of cases at DRT. So we have DRT, DRAT, and then the matter can go to High Court, then Supreme Court, and so on.
So is it 50% of outstanding amount or 50% of the EMIs that have become due?
Outstanding amount.
Entire outstanding amount.
Yeah, which is mentioned in 13.2 notice.
Actually, sir, this is 25%, which is now the decision of the appellate tribunal. It is decided in the Mardiya chemical case, where the 75% was need to deposit, then Supreme Court give it to 25%. That is decided on that case or what?
No. It will be based on the discretion of the appellate tribunal. Now, it is part of the law now. It is not decided in that case, but because of that case, this relaxation has been brought in so that, at least the borrower should not be pressurized now. Because borrower is already in stress. The genuine borrowers are in stress. So some benefit is given in terms of the cash flow part. Okay, so let us answer a few questions on the screen again on the 13.2 enforcement of security interest. Who will make the application, Mr. Sudipta? The aggrieved person. So the aggrieved person is the borrower who can make the application. So B is the correct answer. 30 days from the order was. So somebody was mentioning 60 days. So just let me go through it. So if you want to file an application, it is within 45 days. And in the tribunal, it is 30 days. So it is against an order of DRT, so it has to be done within 30 days. B is the correct answer. Yes. Yeah, I think simple one. 45 days is the correct answer. Yeah, 25% is the correct answer. Yeah, D is the correct answer. Yes, so again, D is the correct answer. Again, D is the correct answer. Yeah. So in this question, I have highlighted the, the main part of the question. So at least you should be able to get it correct. Yeah, so in this case, the correct answer would be, so we are getting different answers, B, C, A, D. Anil Patwalji has mentioned D. Satish sir has mentioned A. Yes, so the correct answer is, yes, D is the correct answer. D is the correct answer. Okay, so coming to the last part, friends, which talks about another agency which has been created by the government of India through RBI, and the purpose is to prevent the fraud in the loan cases. And you have seen, you must have read, you have seen also in your profession in the community, that there are a lot of frauds which have happened in case of loan, where the assets are mortgaged. The assets are mortgaged for to multiple banks and taken loan against that same asset from multiple banks. And that was one of the common phenomena of committing fraud from the banking angle. But then over the last few years, these type of frauds have reduced because of certain steps taken by government through RBI by creating this centralized registry that is known as Sarfesi. It's a centralized electronic registry which has been created under the Sarfesi Act only. Just became operational about 7 to 8 years back only. And still, as I said, because it was new, a lot of things were not clear, a lot of technology issues came in. Now I think things are clear, things have stabilized, and you will find that a lot of records being updated on a regular basis by the banking world. So the crux here is that the centralized registry will create all the databases of all the assets which have been mortgaged by the banks or giving loan to the borrower. And you have any information about any asset, the bankers can access that information and find out whether any loan has been given against that particular property, which the borrower has again trying to give as a security. So this is the whole purpose of this particular central registry which has been created. So the records maintained by the central registry will be available for search by any lender or any other person desirous of dealing with the property. So even if you want to purchase a property today, so you can go to the Sarfesi, pay some fees, and find out whether this property is mortgaged to any other bank or not. Then, so because as in case of company, we can find out the charges from the MCA. The same kind could be found out from this particular Sarfesi. So this was the call of the day, because the companies were more organized, but for individuals, partnership firm, it was not organized. So Sarfesi now created an organized database for finding out all the loans given against a particular asset. So it was a single source to verify charges, if any, on any asset created by any entity. Charges created on the asset of an unregistered entity, including individual, HUF, AOP, and so on. And so the chances of all the false deeds could be eliminated. So this was the purpose of Sarfesi, and quite a successful model. And I think going forward, you must have seen that there is now an information utility which has been created. So Sarfesi came because of Sarfesi, and the information utility is now because of IBC. So this now information utility is a very good technology platform which is creating the database of all the amount which is due from a particular person. So let's say if you have a client today and which is dealing with a particular company, so you can tell your client that please record all your amount which is due from that particular company to that information utility. Because later on, if you want to file a case, that evidence from information utility will always be taken as a priority in all the courts, because court will definitely accept that evidence from IU, information utility. They cannot ignore that. Nobody can dispute that in times to come. So that is why that IU has been created. So today in the first stage, I think all the borrowers, all the bankers, what they are doing, they are feeding all their loan details in their IU, so which will prove there that there's a default. If there is a default, the evidence will be there. So that liberty is given to all the business people. So if you want to load all the information about your debtor, you can load that, and then later on you can take it as an evidence. So Sarfesi, information utility, these are all agencies which have been created, and I think they will go a long way in improving the business environment within the country and reducing frauds and litigations. And we as a professional should try to catch this as an opportunity. So for the purpose of this act, a record called the Central Register shall be kept at the head office of the Central Registry for entering all the details, securitization of financial assets, reconstruction of financial asset, and creation of the security interest. So that information will be created. Then finally, we have the DRT and the DRAT. We all know what is DRT and DRAT. So through this Act of 1993, this DRT was created. And through the DRT, especially with regard to Sarfesi, because I'm not going to details in general, but DRT is a model where is a tribunal where you can file all the cases under Sarfesi, and appeal can be done at the DRAT level. So DRT will, they have 2 recovery officers. Each DRT has 2 recovery officers, and the recovery officer may not be the judicial officer, but then orders passed by the recovery officer is judicial in nature, therefore appealable in the tribunal. So that is the power which has been given. So normally the presiding officer is generally a judge, of the rank of district and session judge. So DRT is playing a very important role in the banking world and with respect to Sarfesi also. Okay, so this covers our whole structure of Sarfesi and Sarsai and DRT, friends. So we had primarily focused on the concept of ARC, the concept of securitization, and concept of enforcement of security interests. These are the 3 things which one should take care. And as I mentioned, friends, we may find a lot of professional opportunities if you get into the world of stress asset funding. Remember, stress asset funding is the major thing which is going to happen in the next 2-3 years. So if you find an opportunity, don't miss it, and you can create a future. Probably you should. It's more of a networking game rather than anything else. So proper network, and you have a proper deal. So any questions? Mr. Satish Chandra, what is the recourse available for unsecured creditors? The only option today is IBC or through your civil court. That is the only option today. If the amount is over 1 crore, then IBC. If the amount is less than 1 crore, then the civil court procedure is the only option left.
Mr. Khandelwal,
Yeah.
You have told that presiding officer is the head of the DRT. Similarly, who is the head of DRAT? What is the position called?
So there the judge sits there.
You have written here the presiding officer is the.
Yeah, so in DRAT it is because it's a tribunal, so there will be a judge.
Judge. What is designation? Here it is called presiding officer of the debt recovery tribunal is the sole judicial authority to hear and pass the judicial order.
Correct.
Similarly, in case of DRAT, who is the final authority?
So the chairman of the tribunal.
Chairman. Okay.
Yes.
The designation is chairman.
Correct.
Okay. So like NCLT and NCLT, president and chairman, here chairman and the presiding officer.
Correct.
Okay.
Right. So any questions? No. So we'll conclude the session out here, friends. So thank you again for attending this session on this Sunday afternoon.
Thank you.